Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. As you guys in the comments section over here can see, I see you already know, this filing in the Texas court by Blake Lively, which includes her motion to dismiss Jed Wallace's amended complaint, is 1,030 pages. I wanted to narrow that down before we got started here, so that's what was taking me so long. I think I've got about 67 pages we'll look over today, because there's like a legislative history and stuff like that I'm going to read through, but I'm not about to do that on camera tonight because I have got to do something else. So we'll go through like the actual motion to dismiss itself, and I think there might be a couple of exhibits to look at, but nothing too crazy. I'm not going to sit here and read 1,000 pages. I will read the whole thing, except for the complaints, which are listed as exhibits, which I've already read like a gazillion times, but so we'll go through just the kind of newer parts, I think, right now. Give me just a second. Okay. Let's see. I don't need that. Nope, don't need that. Clearly I missed some stuff. Okay. Defendant Blake Lively files this motion to dismiss the first amended complaint filed by plaintiff Jed Wallace and his company, Street Relations Incorporated. Now remember, this is in the Texas court, so not the New York court where she has a complaint against him. Part of what they're going to kind of go back and forth about is she did not name him in her initial lawsuits, and then he sued her in Texas, and then she was like, wait, no. And then she sued him in New York. So, yeah. It's Kim. Thank you for the 10 Pacer bucks. Thank you. Yeah, I definitely used those today. Geez. Okay. Thank you very much. I appreciate it. All right. The lawsuit did not... This lawsuit does not belong in this court or in any court. It is not designed to litigate any cognizable claim of defamation. It is the latest in a far-reaching attempt to muzzle a woman for... Fuck off. Jesus. It takes like 3 sentences for these people to... Oh. Okay. It is the latest in a far-reaching attempt to muzzle a woman for speaking out about sexual harassment. No one has ever stopped her from speaking up about anything. She will not shut the fuck up. I swear to God. Not satisfied with their stealth social media retaliation campaign against Miss Lively for reporting on the harassment and misconduct she and others endured on the set of the film It Ends With Us, now plaintiffs and their funders seek retribution by hauling into her court simultaneously in jurisdictions nearly 2,000 miles apart. I mean, she did start this with him, but we'll get into that later. The court should reject this form of judicial harassment and dismiss the amended complaint with prejudice. Wallace and Street specialize in mitigating crises by shaping public perception to the benefit of their high-profile clients and to the detriment of whomever they choose to target. Lady, are you really going to tell me that... Yeah, oh, okay. No. You don't hire like an ex-CIA guy for crisis PR and then complain about somebody else hiring crisis PR. That's ridiculous. In this case, their task was to launch a social media combat plan to bury Miss Lively's reputation, to call her credibility into question, and to conceal the bad acts of some of their clients. Sorry. All in retaliation for Miss Lively reporting sexual harassment and misconduct on the set of the film. Just days after plaintiffs admit they began working on the project, their clients reported starting to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Miss Lively and her husband, and away from the client's own misconduct. Once Miss Lively discovered this retaliatory conspiracy, she exercised her right to petition by filing an administrative complaint with the CCRD. And after receiving CRD's permission to do so, a federal lawsuit in the United States District Court for the Southern District of New York, a case in which Wallace and Street are now parties. Plaintiffs ignore the pending first filed case and attempt to forum shop their claim into this court, alleging that Miss Lively defamed them by including them in the caption of her complaint to the CRD. So she did some sort of... she filed to depose him in Texas, did not name him in the New York lawsuits, and then he ended up suing her in Texas, and then she added him to her amended complaint. So, okay. For the first time in amendment, plaintiffs claim, based solely on information and belief, they were also defamed by unidentified and unspecified statements that happened to occur in Texas, one of which allegedly occurred months before Wallace or Street were even approached by their clients or funders. Another one of the newly purported statements in Texas is not even a statement at all. Astonishingly, plaintiffs now claim that Miss Lively silently defamed them by choosing not to respond when confronted with an individual who called her a liar while declaring justice for Justin. Oh, no. Yeah, that was Kurtz. Colonel Kurtz went out to the Another Simple Favor premiere. My God. Okay. Yeah, so I don't think that she was even aware that Colonel Kurtz was there. It was one person just peacefully holding up a sign. I mean, this whole thing is... all right. And then, of course, the media blows that out of proportion. Like, she was brutally, like, trolled or whatever at her premiere. I was, like, brutally brutalized. Like, I've been more brutalized at a pride parade. What are you talking about? All right. One second. In any case, yeah, I remember in his amended complaints, he did bring up Colonel Kurtz, as well as the girl, I think her name is Kate, in the Waco hotel, that whole incident where she saw Blake Lively coming in and claims that Blake Lively like followed her out to her car and took pictures of her license plate and stuff like that, which we can confirm that she was there because there's a video of that. But as far as the rest of it, I don't know how true that was. But they did bring that up in their amended complaint, so I don't know if she'll mention that here. First, this court is not the right place to hear this lawsuit pursuant to the first to file rule and Rule 12b3 of the Federal Rules of Civil Procedure for improper venue. This court also cannot, consistent with constitutional due process and FRCP 12b2, exercise jurisdiction over plaintiff's claim because Ms. Lively is not subject to personal jurisdiction in Texas. Even if arguendo, plaintiffs could overcome the substantial jurisdictional defects, FRCP 12b6 requires dismissal because the amended complaint fails to state a claim for defamation. I don't think that's true, but all right. Not without a crystal ball, Katie. Hotel Katie. Yeah, not Katie Joy. I'm talking about, God, I wish I could remember her name, but you guys know what I'm talking about, right? Then she had like a bunch of bot accounts and allegedly Ezra Hudson looking at her social media and stuff when that happened. Yeah. All right. Ms. Busted Can of Biscuit says, this appears to be rehashed bullshit. I'm so irritated. A lot of it will be because he didn't like respond to her motion to dismiss. He just did he amended his complaint. So a lot of it is going to be the same because of a lot of his amended complaint was the same as the original one. But, you know, we'll see. Ms. Lively is an actress and entrepreneur. Yes, very successful hair care specialist who resides in New York, New York. She starred in the film, which Justin Baldoni directed, and which Wayfarer Studios, the movie studio owned by Baldoni and his billionaire business partner Steve Sarowitz, produced and owns. Ms. Lively reported sexual harassment and misconduct that occurred on the set of the film. Actually, no, she didn't. Not until long after when it suited her because she was upset that her hair care line was not, in fact, all that successful. But okay. I digress. Okay. Including that Baldoni divulged information about his sex life, made derogatory, degrading, and sexual comments, described his own genitalia. Okay, excuse me. Your husband texted this man how much he adored him and how he wanted to tattoo, I think it was his name, on your husband's perineum. Can you get off your holier-than-thou bullshit, please? Not only that, but I absolutely do not believe that happened. No. Improvised unwanted intimacy that had not been rehearsed, choreographed or discussed with Miss Lively in advance, added graphic content to the script, including multiple new scenes with nudity and on-camera orgasm. Heaven forbid that they try to get the scene right, you know? I mean, that is the job that she signed up for, playing the love interest and the main character. So, like, dude, get your shit together. And added unscripted nudity to a birthing scene for which he cast his friend as Miss Lively's OBGYN. We're still going with that one, really. Even though the guys come out and said, I don't know what you're talking about, she was not nude, and what the fuck. A resulting signed contractual rider laid out 17 specific protections to ensure a safe set, including a mandate that Baldoni, Heath, Wayfarer, and others not retaliate against Miss Lively for raising concerns or requesting safeguards. You'll notice Jed Wallace has nothing to do with any of this. As promotional events for the film began in the summer of 2024, Baldoni became concerned that Miss Lively would speak publicly about the on-set harassment and solicited the assistance of crisis management expert Melissa Nathan and her company, TAG. Jennifer Abel and Sarowitz, who promised to spend $100 million to ruin Miss Lively's and her family's lives. Again, we've never seen this actually, like, it was not in writing. She just continues to parrot that. I don't know if he ever actually said that or not. As far as the crisis management experts, why the fuck would you not get a crisis management expert when this person is like, she took over your film, she's excluding you from the premiere and all the press stuff, and it looks really bad. So yeah, I probably would too. According to the amended complaint, Wallace and Street were first approached by TAG on August 7th about assisting it in social/digital mitigation and remediation regarding Wayfarer Studios. Wallace is the owner and founder of Street, which describes itself as a crisis mitigation firm, primarily helping families and individuals who find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or needing help navigating their most frightening situations. Well, that is the true hallmark of a horrible person. I mean, wow. Pack it in now. Wallace incorporated Street in California in 2008 and converted it to a Texas corporation on February 6th. After filing this lawsuit. Listing the address of the California law firm of lawyer Brian Friedman, who serves as counsel for Baldoni, as both the organizer of the corporation and as Street's California agent for process. Plaintiffs confirm in the amended complaint that they began work on the project on August 9th and performed work regarding the film and its two stars, Justin Baldoni and Blake Lively. Ms. Lively filed a complaint with the CRD in December 2024 to report sexual harassment retaliation. On December 20th, Ms. Lively filed an administrative complaint as a prerequisite to initiating a lawsuit in federal court. That included 1, a required intake form, 2, an attachment that detailed the misconduct in the form of a federal complaint. Okay. Is there a 3? No. The CRD form included a caption that named Miss Lively as the complainant and 10 respondents and stated as follows. We kind of know what that said, so I'm not going to fuck with that too much. The attached CRD complaint named the same 10 individuals and entities in its caption and in its 62 pages explained the specific details in the form of factual allegations that form the basis of Miss Lively's claims. The nearly 50-paragraph factual background section detailed the sexual harassment that Miss Lively and others faced on the set of the film. Not really, at least not well. I mean, okay. The remaining 125 paragraphs, as described immediately below, detail the retaliatory plan that Wayfarer, Baldoni, Heath, and Sarowitz launched after the film's production in the summer of 2024, with the assistance of TAG, Nathan, Abel, and the plaintiffs, and relied heavily on text messages exchanged amongst some of the defendants. Yeah, how did you come to possess those, by the way? We want to talk about that? No. Other than a caption, Wallace's name appears only in 7 paragraphs of the attached CRD complaint, all of which relate to the retaliatory campaign, and the majority of which refer to Wallace in the context of text communications that identify him by name. Street is not mentioned except in the caption. As described in the attached CRD complaint, TAG provided Baldoni, Heath, and others a scenario planning document on August 2nd that suggested that if Miss Lively made her grievances public, they could get ahead of this narrative by pushing that she had a less than favorable reputation, planting stories about the weaponization of feminism, and misleadingly blaming Miss Lively for production members' job losses. So I still don't know much about the job losses part of this, but as far as the weaponization of feminism, look at what she just did on Seth Meyers, and what she did at the Time Gala. Like, tell me she's not weaponizing feminism at this point. Don't even give me that. Like, this lady was promoting a movie about domestic violence and didn't have a care in the world about people who had been abused or harassed or whatever. And in fact, gave some pretty snarky answers when asked about like what survivors could do if they wanted to reach out and that kind of thing. And then she was saying something about like, should I share my location with you? So like, I don't really want to hear her now go on talk shows and talk about how she's a champion for women and girls. Honestly, no. Okay. One sec. Okay. After Baldoni responded by explaining that he was not feeling the protection I felt on the call, Abel and Nathan commiserated over text. Okay. Well, we've seen all this before. He wants to feel like she could be buried. We can't send over the work we will do or could because that could get us in a lot of trouble. We can't write it down to him. We can't write we will destroy her. And if you know anything about this man at this point, you know that he would be pretty upset if they were to write stuff like that, because you never hear the guy say a bad word about anybody. Even these people who treated him like shit, he was out there in the press like singing their praises. Because nobody wanted to see the film not do well, except for maybe Blake if she didn't get her way. Right. Nathan followed with the text, we can bury anyone, but I can't write that to him. The next day, Ms. Nathan provided pricing quotes ranging from $75,000 per month for a minimum of 3 months for the creation of social fan engagement to go back and forth with any negative accounts, helping to change the narrative, to $175,000 for a 3 to 4 month period for full Reddit, full social account takedowns, full social crisis team on hand for anything, including to engage with audiences in the right way, start threads of theories. Okay. Ms. Nathan emphasized all of this will be most importantly untraceable. On August 7th, Abel and Nathan agreed that we really need to put the social combat plan into motion. That plan, as Abel described it, was to engage in social media mitigation and proactive fan posting to counter the negative and social manipulation. On August 8th, and in response to an online post criticizing Baldoni, Abel confirmed that we flagged to Jed and his team for more serious action on the social side. By August 9th, the day plaintiffs alleged that they began to work on the project, Wallace reported to Nathan that we are crushing it on Reddit. Okay. Now, give context. The we are crushing it on Reddit was part of him telling them, we don't need to do anything. It's organically going our way. See, that's conveniently left out here. At the end of the day, Abel, Baldoni, Heath, Nathan, and other members of Tag Team exchanged text messages to celebrate that they had confused people with mixed messaging. And Abel commented that the narrative online is so freaking good that she viewed the day's work as a total success, as does Justin. No, it's super interesting. She didn't include the actual text, just the text of the text. I don't know, man. On August 10th, a Tag employee noted that they had started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Later that day, Nathan texted Abel that the majority of socials are so pro-Justin and that he doesn't realize how lucky he is right now. She wrote, the socials are really ramping up, and it is actually sad because it shows you have people really want to hate on women. And again, they've used this text. Stephanie Jones and Blake Lively have both used this one text message to try to say that this is them referring to the both of them. So which one is it? In the days that followed, plaintiffs worked with Nathan, Abel, and Tag to amplify or boost or suppress certain narratives and posts on social media. For example, on August 18th, TAG told Baldoni that they would let Digital know about a TikTok video Baldoni circulated in which the poster criticized Miss Lively. Okay. What do you mean? I need you to be more specific about that. What do you mean he circulated? What did the video say? Were they criticizing her hair care line? Because people apparently had some pretty valid criticisms of that. I'm just saying. And that's what you were advertising the whole time you were promoting this stupid... All right. The same day, Nathan proposed that they chat to Jed as well on this in response to a negative story about Baldoni. Well, heaven forbid. Heaven forbid you consult your crisis PR team. All right. The day after Ms. Lively filed the CRD complaint on December 21st, the New York Times published an article reporting on the allegations entitled "We Can Bury Anyone." Yeah, let's pretend that they just casually published that because they got everything on their own. But that's... Okay, sure. 10 days later, both plaintiffs, along with the other individuals and entities identified in the CRD complaint, and all represented by Friedman, initiated a lawsuit against the New York Times in California State Court, including based on assertions that the article defamed them by stating that the plaintiffs orchestrated a retaliatory public relations campaign against Lively for speaking out against sexual harassment. She didn't speak out about sexual harassment. She invented that at some point. But, okay. And that they waged an affirmative campaign to harm Lively by planting news stories to shape social media discourse. The California complaint identified Street as a California corporation at all relevant times. Ms. Lively initiated the New York litigation and filed a Rule 202 petition in Texas seeking discovery with respect to Wallace. On the same day that plaintiffs filed suit against the New York Times in California, Ms. Lively initiated the New York litigation with a complaint nearly identical in substance to the attached CRD complaint, and which asserted federal and California state law claims against the Wayfarer parties. Okay. On January 16th, all the New York Wayfarer defendants filed a separate lawsuit in the first filed court, asserting 7 causes of action, including based on the allegation that the CRD complaint was rife with lies and doctored evidence. On January 21st, Ms. Lively initiated a Rule 202 petition in Hayes County to obtain a pre-suit deposition of Wallace in order to investigate the full nature and scope of his role in implementing and carrying out the retaliatory campaign. On January 22nd, process servers hired by Ms. Lively made the first of 7 attempts to serve Wallace, who continually refused to accept service. Okay. All right. On January 23rd, the process server received a text from an associate at Friedman's law firm stating, the law firm, Friedman, Tatelman, Cooley, will accept service for him. Do not try to serve him again. Thank you. Later that day, Friedman told counsel for Ms. Lively that my office never agreed to accept service of process of anything. Ms. Lively also attempted to serve Wallace by certified mail, which he again refused to accept. Okay. After Friedman represented to the first filed court that all related claims should be heard there, Ms. Lively withdrew the Rule 202 petition and amended the New York litigation to add plaintiffs as parties. On January 31st, the New York Wayfarer defendants, without being joined by Wallace and Street, notwithstanding there being plaintiffs in the California complaint, filed an amended complaint in the New York litigation to include the New York Times as a party. The parties to the California complaint, including Wallace and Street, dismissed the California complaint on February 3rd. The first filed court held an initial pre-trial conference on the same day, during which Friedman explained his reasoning for filing an amended complaint to include the New York Times and dismissing the California action. So what they're quoting here, and again, if you want to look through that February 3rd transcript of that court conference, I have it out here somewhere. I think it's attached to this filing too. I left it out for tonight. After seeing your case management order and just for the efficiency of the case, it kind of made no sense to be doing this on different coasts and with different courts. So they're talking about how they dropped the complaint against the New York Times in California. Okay. During the same hearing, counsel for Ms. Lively represented to the first filed court that she would be amending her complaint to add additional parties and claims. The next morning, Ms. Lively filed a notice non-suiting her Rule 202 petition that referenced Friedman's representation to the first filed court. As of that date, Ms. Lively had been unable to serve Wallace. That same day, the afternoon of February 4th, and despite the representations made to the first filed court the day before, Wallace and Street initiated this lawsuit in Texas, asserting a claim for defamation and seeking to obtain issue preclusive effect by asking this court to declare that plaintiffs are not liable for claims that they anticipated Ms. Lively would bring against them in New York litigation. After filing the original complaint, plaintiffs sent a letter to Ms. Lively demanding a retraction, correction, or clarification, to which Ms. Lively responded by requesting additional information. On February 18th, Ms. Lively filed an amended complaint in the New York litigation, adding plaintiffs as parties and asserting against them claims for aiding and abetting harassment. How? Aiding and abetting harassment and retaliation, intentional infliction of emotional distress, false light invasion of privacy, and civil conspiracy under California law. Plaintiffs filed the amended complaint after Ms. Lively moved to dismiss. After Ms. Lively moved to dismiss the original complaint rather than respond, plaintiffs filed the amended complaint, asserting a single cause of action for defamation and defamation per se, based on the contents of the CRD complaint, and on alleged identical or similar statements that plaintiffs claim based solely on information and belief were made in Texas. Plaintiffs claim the CRD complaint defamed them because, 1, its caption and overall gist created the impression that all causes of action, severe allegations of sexual harassment and violations of California and federal law, are attributable to all defendants. And 2, its general thrust and gist falsely accused plaintiffs of participating in the retaliation campaign, including in the following bolded language in 2 paragraphs. Okay. We've already seen this, so I'm not going to go through all that. For the first time in the amended complaint, plaintiffs assert that Ms. Lively or others, based on their expansive definition of lively, made identical or similar statements in Texas. That assertion is based on allegations that, upon information and belief, there were identical or similar statements made in Texas, specifically that Ms. Lively, 1, never admitted that her statements were false, in response to a Texas resident confronting her during an appearance at South by Southwest in Austin by stating Blake lies and referencing Justice for Justin. I can't believe this made it into this. This is ridiculous. 2, made additional defamatory comments about plaintiffs at a hotel in Waco. Okay, well that, I'll admit that's yet to be seen, but. And 3, promoted the film at the June 2024 Book Bonanza event in Texas, during which Discovery may reveal whether she made any additional defamatory remarks about plaintiffs. As to all information and belief statements, the amended complaint alleges that Discovery will reveal the extent of the statements. All right. One sec. All right. This punitive and meritless lawsuit requires dismissal out of the gate because plaintiffs filed it in the wrong court. This case is a blatant attempt to further penalize Ms. Lively for speaking out by forcing her to fight claims arising from the same set of facts on 2 cross-country fronts. The court can and should dismiss the amended complaint in its entirety before considering its substantive claims based on threshold grounds for denying audience to a case on the merits. The first to file rule demands dismissal. Okay. Federal courts, including the Fifth Circuit, long have recognized that the principle of I don't know that word, comedy? requires federal district courts, courts of coordinate jurisdiction and equal rank, to exercise care to avoid interference with each other's affairs. Whereas here, there exist parallel federal actions where the core issues, proof, questions, or subject matter might substantially overlap the proper course of action. For the second filed court is to defer to the first filed court and dismiss the lawsuit. Okay, this is where I'm going to skim over a lot of this stuff. There is no question that substantial overlap exists between this case and the New York litigation. The amended complaint and its claim are based on the CRD complaint that Ms. Lively filed in order to receive permission to file the New York litigation, and which is virtually substantively identical to the complaint she ultimately filed there. There is not just a likelihood of substantial overlap between the two cases, there is a guarantee of full overlap. Well, then why didn't you name him in your lawsuit? All right. Both cases are essentially mirror images of each other, as evidenced by the fact that the claims plaintiff originally asserted in the California complaints, which express the same grievances as they plead in this case, are now part of the New York litigation. The court need not engage in further analysis to apply the first to file rule and dismiss the amended complaint in its entirety, putting a stop to the multi-jurisdictional judicial harassment against Ms. Lively. Everything's harassment to you. Jesus. Plaintiffs may attempt to argue that this case, not the New York litigation, is the first filed case because Ms. Lively did not add plaintiffs to that lawsuit until after they filed this one. Okay, well, thanks for at least addressing my question, I guess. But the first to file rule does not require complete identity of parties and focuses instead only on whether there is a likelihood of substantial overlap between the two suits. Okay. One sec. Nor should the court reward plaintiffs who admitted in their original complaints and a representation they have removed in the amended complaints that they filed this case against Ms. Lively in this court because they were threatened with liability and hoped for an early adjudication without waiting until Ms. Lively should see fit to begin an action against them. Dismissal is the appropriate result given the likelihood of substantial overlap described above, and to avoid rewarding plaintiffs for their evasive tactics, anticipatory filing, and forum shopping. 2, this court is not the proper venue for plaintiff's claim. This case warrants dismissal for improper venue because plaintiff's claim for defamation does not arrive from a substantial part of the events or omissions that occurred in this district. Plaintiff's claim in connection with the attached CRD complaint arose in California, where the alleged defamatory conduct occurred, not any events that occurred in Texas. And even if that were not the case, the substantial part of the activities from which plaintiff's claim arises is the CRD complaint, not unspecified statements that plaintiffs added to the amended complaint solely to attempt to manufacture jurisdiction and venue in a state and judicial district that have nothing to do with their claims. Nor can plaintiffs satisfy Section 1391b2 in this case by claiming a substantial part of the underlying events Ms. Lively sought to investigate in the Rule 202 position occurred here. Plaintiff's claim for defamation arises from the CRD complaint, not from the filing of a Rule 202 petition. Further, where plaintiffs conducted their business, i.e. the location where Wallace participated in the retaliatory campaign against Ms. Lively, is irrelevant to the venue analysis because actions taken by a plaintiff do not support venue under Section 1391b2. Even if true that plaintiffs felt injury in this district, that would not make it a proper venue. This court lacks personal jurisdiction over Ms. Lively. Okay. The court lacks specific or general jurisdiction over Ms. Lively. Plaintiffs do not assert that general jurisdiction exists over Ms. Lively in Texas, nor could they because Ms. Lively is a citizen of New York. Nor do they meet their burden to establish a prima facie case for specific jurisdiction because they failed to plead facts demonstrating that Ms. Lively purposefully availed herself of the privilege of conducting activities in Texas, or that plaintiffs' claims arise out of or relate to those purposeful contacts. Okay. The Rule 202 petition does not subject Miss Lively to personal jurisdiction. One sec. For the Rule 202 petition to amount to purposeful availment, plaintiffs must but cannot demonstrate that by filing it, Miss Lively initiated an original action in the state or litigated extensively on the merits. Despite plaintiffs labeling the Rule 202 petition the Texas lawsuit, courts in Texas consistently have held that a Rule 202 petition is not an original action because it merely authorizes the taking of a deposition to investigate a potential claim or suit. Nor does filing a Rule 202 petition demonstrate extensive litigation on the merits because it is not a legal claim on the merits at all. And even if it were, the filing a non-suit prior to service do not qualify as having litigated extensively. If filing the Rule 202 petition constitutes purposeful availment, it still would not permit the exercise of personal jurisdiction over Miss Lively because, as discussed above, plaintiff's claims do not arise out of or relate to its filing. If Miss Lively had never filed the Rule 202 petition, plaintiff's claims about the CRD complaint would remain intact and unchanged. The Rule 202 petition provides no basis to subject Miss Lively to jurisdiction in this state. The Calder effects test does not justify subjecting Miss Lively to personal jurisdiction with respect to the CRD complaint. Plaintiffs appear to advance a theory of specific jurisdiction based on Calder v. Jones by alleging that the CRD complaint was aimed at Texas, where both plaintiffs reside, and they undoubtedly caused harm because 2 of the 203 paragraphs in the attached CRD complaint specifically state that Wallace is based in Texas. To meet the Calder standard, plaintiffs must but cannot show that plaintiffs' activities in Texas, or the state itself, is the focus of the subject matter of the CRD complaint, and the CRD complaint relied on sources located in Texas. I don't know if y'all can hear that, but there's a plane going overhead. Is the focus of the subject matter of the CRD complaint, and the CRD complaint relied on sources located in Texas to provide new and substantial disclosures. Plaintiffs do not even attempt to meet the second requirement, and the court can and should reject the application of Calder on those grounds alone. The focal point of the attached CRD complaint, the publication on which their claims are based, is California. Miss Lively filed it with a California administrative agency based on violations of California law by her California employers and by their co-conspirators, all of whom had direct connections to California, based on activities that occurred outside of Texas. Wallace has submitted a sworn declaration in the New York litigation attesting that he understood his work, which is part of the factual basis of the CRD complaint, was directed exclusively to California. Okay. Plaintiff's allegations of harm in Texas are insufficient to render it to the focal point. Plaintiff's new attempt to manufacture Texas-based contacts does not establish personal jurisdiction over Miss Lively in this case. All right. The amended complaint's allegations relating to the information and belief statements cannot satisfy plaintiff's burden to plead facts that establish a prima facie case of personal jurisdiction at the motion to dismiss stage. As discussed in detail below, the information and belief statements fail to comply with the most basic requirements of Rule 8, and even if they did, do not demonstrate a cognizable claim of defamation. Pleading on information and belief is recognized as little more than a lawyerly way of saying that the plaintiff does not know that something is a fact, but just suspects it or has heard it. Plaintiffs cannot, as a matter of law, establish a prima facie case of personal jurisdiction by relying solely on conclusory, implausible, and wholly unsupported allegations of fact. Okay. Plaintiff's inability to plead any allegations or evidence regarding the content of the information and belief statements defeats their burden. Right. Failure to state a claim for defamation. Plaintiffs fail to plausibly allege the elements of a defamation claim, including 1, a specific defamatory statement, 2, defamation by implication, 3, fault, and 4, damages. Even if plaintiffs can surmount these basic hurdles, which they cannot, the claim fails for the additional reason that the CRD complaint is subject to multiple privileges under California law, and therefore constitutes protected speech. The amended complaint does not comply with Rule 8. Despite having had the opportunity to amend their complaint, plaintiffs still have failed to meet the particular pleading that Rule 8 requires to sufficiently state a claim for defamation. Okay. To comply with Rule 8 in the context of defamation, plaintiffs must not only specifically state the time and place of publication, but also must include allegations specifically identifying the alleged defamatory statement and the speaker. They fail to do so in multiple ways. The amended complaint violates Rule 8 by relying on impermissible group pleading rather than identifying the speaker of any specific statements. Plaintiffs define Lively not to refer to Miss Lively herself, but to include her agents, including her lawyers, consultants, and husband, Ryan Reynolds. Are we now admitting that Ryan Reynolds is an agent for Blake Lively? Okay. Or maybe I guess they're just saying that's what how they're referring it. I don't know. That's kind of funny, though. And their related entities, including but not limited to Betty Booze, Blake Brown, Aviation Gin, Mint Mobile, and Maximum Effort Productions. In other words, any allegations in the amended complaint may refer to any number of unspecified individuals or corporate entities who may be associated with Miss Lively or her husband, without any indication as to whom or why Miss Lively is liable for that conduct. Such unadorned accusations and sweeping generalizations of unnamed agents without any further factual enhanced and which reveal nothing and only intimate a sheer possibility of wrongdoing requires dismissal. The amended complaint fails specifically to identify the alleged defamatory content. As to the information and belief statements, the amended complaint does not identify any statement at all, relying only on general suppositions that Miss Lively or others may have said something, but they cannot say what exactly she may have said, when or to whom, if she even said anything at all about plaintiffs while in Texas. The amended complaint's failure to identify the content of the information and belief statements is fatal, and plaintiffs cannot force Miss Lively to speculate as to what potentially defamatory statement she made in order to defend herself. Plaintiffs bear the burden of pleading allegedly defamatory statements now and may not rely on what they believe discovery may show. The amended complaint does not plausibly plead any statements capable of a defamatory meaning. Leaving aside that the amended complaint violates Rule 8 and any statements contained in the CRD complaint are protected as privileged, the amended complaint does not plausibly allege any facts demonstrating any statements are capable of a defamatory meaning. Plaintiff's primary theory is the CRD complaint defamed them by implication, i.e. that it implies plaintiffs engaged in sexual harassment because someone would see the caption and believe that all the individuals listed engaged in all of the causes of actions. That theory fails as a matter of law because such an inference is unreasonable. One sec. The CRD complaint identified all defendants, including plaintiffs, opposite a list of the causes of action alleged, which is a common practice in many jurisdictions and required in California state courts. And the body contained detailed factual allegations related to her claims. None of the 7 paragraphs of allegations in the CRD complaint that mention Wallace state or suggest that either he or Street harassed Ms. Lively. The entirety of the CRD complaint, which the court is required to consider, makes clear that Miss Lively was accusing plaintiffs of engaging in a campaign of retaliation after the alleged harassment, including by expressly alleging that the retaliation campaign for which plaintiffs were hired began months after filming wrapped. Even the lone media report plaintiffs claim mentioned Wallace understood the CRD complaint did not accuse him of harassment, but only being part of the effort to tarnish Lively's reputation, which she did so well on her own. Plaintiff's theory that the challenge statements in particular, and the CRD complaint as a whole, defamed plaintiffs because they did not engage in retaliation or create, seed, and promote content on social media platforms and internet chat forums and were not retained by TAG, do not convey a defamatory meaning. Those allegedly defamatory statements cannot support a claim because they are not more damaging to plaintiff's reputation in the mind of the average person than the following pleaded admissions. Okay. Wallace is the owner and founder of Street. Street is a crisis mitigation firm. Miss Lively reported sexual harassment had taken place on the set of the film. TAG approached plaintiffs after the filming of the film about assisting in social/digital mitigation or mediation. Plaintiffs agreed to and began to perform work 2 days later on August 9th. Plaintiffs performed a job for TAG, Wayfarer, and Baldoni, and provided advice to TAG and Wayfarer regarding public reaction to the film. So I remember I don't remember if it was in the initial complaint, but it was at least in the amended complaint, he's pointing out that like her claim of him doing all this, it falls outside of the timeline where he started doing his work. So she kind of did a tremendous job of ruining her own reputation, and then he came in to help them with whatever they wanted him to help with. And she's saying that he's the reason for all this happening, basically, or he's part of the reason for all this happening, when her claims of them ruining her reputation and all that predates his involvement. So, okay. One sec. Okay. Whatever disagreement plaintiffs may have with the minutia about about the type of work plaintiffs performed, whether they would characterize it as retaliation or who ultimately paid them, does not change their own admissions that TAG approached plaintiffs in August 2024 to assist Wayfarer in social/digital mitigation and remediation in connection with Miss Lively's claims of sexual harassment, and 2 days later began to perform work on a project relating to the film, Baldoni and Miss Lively. As far as whether plaintiffs were retained by TAG or paid by someone else, perhaps Mr. Sarowitz, as part of his $100 million campaign to ruin Miss Lively's life, please find new ways to tell me how butthurt you are about that alleged statement. God. Does not negate plaintiff's admission. I'm sorry. Does not negate plaintiff's admission that they were retained to perform work in connection with Miss Lively's claims of sexual harassment. Moreover, the question of who retained them is not capable of a defamatory meaning. Factual allegations about the information and belief statements defeats plaintiff's burden to plausibly demonstrate the existence of any defamatory statements. Plaintiff's theory with respect to the South by Southwest silence is that Miss Lively conveyed, I need to go to sleep, a defamatory implication by choosing not to respond to an individual telling her Blake lies and justice for Baldoni. I mean, it's kind of interesting the way they characterize this, because honestly, I think Colonel Kurtz was wearing a shirt that might have said justice for Justin or something. She had a sign. No, maybe it was on the sign. I don't know. She had a fucking rainbow glittery sign, and she held it up, and she didn't really bother anybody, much less Blake. But so I'm kind of surprised that this really made it into these. Jed's filing, and obviously, I guess she has to respond to that. But like, it's just such a weird thing to make a huge deal out of. But all right. In other words, plaintiffs perversely seek to punish Miss Lively for showing restraint by saying nothing about them at all. Okay. Such a claim fails as a matter of law because silence alone does not constitute a defamatory statement. I'm going to be honest, man. I think they might have a point there. I mean, I honestly, and you know, the lawyers who go over this kind of thing can explain this in a way that maybe makes, if this falls under some sort of legal issue. But honestly, I don't get it. Like, I don't get why they're saying that was defamation. And I kind of understand what they're saying here. Like, I don't like that I understand the reasoning here, but I do. All right. Taken to its logical conclusion, plaintiff's argument would impose liability on anyone who chooses to remain silent on a topic when confronted, including, for example, plaintiffs or their counsel refusing to admit that their mutual clients sexually harassed and retaliated against Miss Lively. Well, I'm sure they might if anyone had sexually harassed her at all. Okay. Such an argument not only is wrong as a matter of law, it is frivolous and reflects the extent to which plaintiffs will conjure fantastical facts and legal theories to punish Miss Lively. As far as book bonanza, well, you want to conjure fantastical facts and legal theories to punish someone, look no further than Blake Lively's complaint against Justin Baldoni. But all right. As far as book bonanza, plaintiffs plead that the event occurred before TAG had even approached plaintiffs, which makes it implausible that Miss Lively's published any statements about them. With respect to whatever occurred in Waco, there are no allegations from which the court can infer that Miss Lively made any defamatory statements about plaintiffs. While apparently these nondescript claims have been formulated to manufacture jurisdiction, they failed to provide facts sufficient to state a claim, and plaintiffs cannot meet that burden now, not based on what they hope discovery may reveal. Plaintiffs fail to plead facts demonstrating negligence. One sec. Lauren loved the hair. It was too quiet today. Yes. Well, thank you. I put water on it. It's just wet, but thanks. The amended complaint cannot survive dismissal because it does not include any allegations demonstrating negligence, which plaintiffs must do assuming they intend to contend that they are private figures. To sufficiently plead negligence, plaintiffs must show that the defendant should have known that the published statement was false at the time of its publication. As applied here, plaintiffs must convince the court that Miss Lively should have known that plaintiffs did not assist the Wayfarer parties, Tag, Nathan, and Abel, in the retaliatory efforts to bury her. Such a conclusion would be directly contrary to plaintiffs' own admissions that they did assist Wayfarer, Baldoni, Tag, and others. What's more, the factual basis for Miss Lively's belief that plaintiffs were involved in the retaliation campaign is laid out in the CRD complaint, which plaintiffs incorporated into the amended complaint, including texts about plaintiffs showing their direct coordination with Tag, Wayfarer, Baldoni, and Heath. So the footnote here says Miss Lively does not concede that plaintiffs are private figures, but assumes so for purposes of this motion, even though the complaint never says as much. Miss Lively also does not concede that the amended complaint sufficiently pleads actual malice, but she does not engage with those allegations at this time, given that plaintiffs cannot even demonstrate the negligence standard. Okay. Far from demonstrating negligence, the amended complaint and CRD complaint both show why Miss Lively had every reason to have known that the statements in her CRD complaint were and remain true. Well, that's a stretch. The crux of plaintiff's allegations relating to fault relates to Miss Lively's decision to initiate the New York litigation without originally naming plaintiffs and to instead seek a pre-action deposition by filing a Rule 202 petition. Both of these decisions postdated the filing of the CRD complaint and therefore offer no probative value as to what she should have known at the time the allegedly defamatory statements were made, i.e. when she filed the CRD complaint. But even aside from the timing, the allegations fail to demonstrate negligence. Plaintiffs claim that Miss Lively's decisions surrounding the Rule 202 petition reflect that she had no evidence to support her claims is a conclusory assertion that the court need not accept, but it also ignores that Ms. Lively has since added the plaintiffs to the New York litigation. The amended complaint in that action adds additional allegations about plaintiffs, including text referencing conversations in which Wallace participated and the work performed. The example she gives here is Abel asking Tag if Tag could get plaintiffs up to speed so they could hit the ground running, working to amplify or boost. Wallace reaching out to Nathan for a Zoom conversation. This is like very vague. But all right. See also Wallace boasting about having a proprietary formula for defining artisan trends. So? Plaintiffs cannot reconcile their theory of negligence at the time of Ms. Lively's filing of her CRD complaint with her decision to add plaintiffs as parties to the New York litigation based on the same and additional allegations as those contained in the CRD complaint. The alleged statements are not defamatory per se, which means plaintiffs have failed to adequately allege damages. They're still referring to stolen text and out of context communications. Yeah, that's true. Hi, Jay. What's going on? All right. Plaintiffs allege that the defamatory statements are per se because they accuse plaintiffs of conduct which is criminal and injure them in their profession. Section 42.07 is a Texas criminal harassment statute that is irrelevant for multiple reasons, including because Ms. Lively asserted only civil causes of action in the CRD complaint and only under California, not Texas law. The two statements in the CRD complaint about plaintiffs are factual descriptions of their job and are not so obviously harmful that general damages may be presumed. Because plaintiffs fall short of articulating a defamation per se claim, plaintiffs must show actual damages for this lawsuit to survive. The First Amendment complaint does not include specific factual allegations that any of the allegedly defamatory statements caused plaintiffs to suffer any reputational harm, let alone $1 million. Conclusory assertions that are insufficient are, as are allegations about Wallace's emotional condition to adequately plead damages. Okay. The CRD complaint is privileged as a matter of California law. The court should apply California law to the privileges asserted by Ms. Lively. There is a conflict between Texas and California privilege law because California law provides more expansive protections to fair reports, official documents, and statements about sexual harassment and retaliation than Texas law. California has the most significant relationship to the plaintiff's claim because, one, the public policy factors listed in Restatement of Conflict of Laws, and two, the four factors from the Restatement, second, of Conflict of Laws, favor applying California law to determine whether Ms. Lively's alleged statements are privileged. The Section 6 factors favor California law because, as explained below, California has articulated a strong public policy to shield individuals who speak out about sexual harassment from defamation claims under California Civil Code, Section 47.1. And fuck you for exploiting that, by the way, which would be furthered by its application in this case. Texas has no such policy, and those who make statements in California should expect to receive the protections under Section 47.1. Additionally, the court can easily apply the privilege here. Okay. The Section 145 factors also favor California law because, as described above, this case is about Ms. Lively filing the CRD complaint in California, and the conduct causing the alleged injury relating to the publication of the CRD complaint occurred in California. Is that even true? Conduct caused the alleged injury occurred in California. I mean, I guess if we're talking specifically about Jed, who I guess did say in his statement that, you know, his work was related to California, but we'll see. Plaintiffs both have business ties to California, and Street was organized there as of the filing of this action and throughout the period covered by their allegations. While there is no location where the parties' relationship is centered, Wallace's sworn declaration in the New York litigation discussed above confirms he understood he was doing business and providing his services to individuals in California, and that is where he considered the impact of his work to be located. All right. Litigation privilege provides absolute protection for all statements contained within the CRD complaint. The CRD complaint is absolutely protected by California's litigation privilege, which provides a broad absolute privilege for statements made in judicial proceeding or any other official proceeding authorized by law, including those involving administrative agencies like the CRD. The litigation privilege bars plaintiffs' attempts to sue Ms. Lively for any statements contained within the materials submitted to the CRD. And that fucking sucks, man. I'm sorry. I know why it's there. I know what it's supposed to do. But obviously, some rich, entitled asshole can use it to get her way and possibly get away with it. That's yet to be seen. But something's not right with that. Like, Jesus. Whether Ms. Lively subsequently initiated civil litigation, which of course she did, is irrelevant as the form the complaint takes, as is the form the complaint takes. The fair report privilege bars any claims based on providing the CRD complaint to the media. In an attempt to circumvent the protections of the litigation privilege, plaintiffs allege that Ms. Lively or her agents provided the CRD complaint to many media outlets. But such conduct, even if true, is absolutely protected by the common law fair report privilege and the fair report privilege under California law, which applies to a fair and true report true report is, or a communication to a public journal of A, judicial, B, legislative, or C, other official proceeding, or anything said in the course thereof. Yeah, okay, but that wasn't in existence when they started working with that publication. I don't know if that matters or not, but we all know now they got those text messages back in September, October, a couple months before, which lines up with the timeline of when the New York Times supposedly started writing that article, which was at least back in October. So CRD complaint wasn't even a thing at that time. Again, I don't know how much that matters, but indeed, the explicit purpose for expanding the privilege to include communications in a 1996 amendment was to protect communications to the media and abrogate a case that held that an attorney's transmittal of a pleading to a newspaper was not protected. The sexual harassment privilege protects Ms. Lively's allegedly defamatory statements. And again, that's one of the most fucked up things about all of this. And I maintain that sucks because it's not like I don't want things like this to be in place to help people who actually need it, but it's too big of a weapon for people who, it's not there for them. Ms. Lively's allegations regarding sexual harassment and retaliation fall squarely within Section 47.1, which provides broad immunity for communications made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination, whether in a legal proceeding, to the press, or otherwise. Without malice regarding an incident of sexual assault, harassment, or discrimination. Well, none of that is accurate, but to be protected by the sexual harassment privilege, the speaker need only have, or at any time had, a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. That's just so... Okay, hang on. Reasonable basis to file a complaint. But then couldn't any delusional psycho just kind of exploit, or not exploit that even, use it and when it's not proper? And then by the time they figure that out, it's the other person's life is over? There's a lot about that I don't understand. I'm not gonna lie to you. So maybe I'm just reading it wrong. It's definitely possible. In other words, the sexual harassment privilege attaches regardless of whether a complaint is ever filed and no matter to whom the communication is published. It's fucked up. The statute was enacted in large part to address defamation claims filed against harassment victims based upon statements made to the press. Well, you want to undo any good that it did, by all means, proceed with whatever the fuck you're doing here. As explained by California's legislature, the protection applies to individuals who, after relaying any factual statement, whether on the form of a formal complaint or a statement outside of formal proceedings, such as to a media outlet, are sued for defamation. Hey, CJ. The sexual harassment privilege applies here because the CRD complaint is a communication made by Ms. Lively regarding incidents of sexual harassment. I mean, they're like La La Land fantasy stories, but sure. And the amended complaint fails to allege that Ms. Lively lacked a reasonable basis to file the CRD complaint or did so with malice. Indeed, plaintiffs previously admitted that Ms. Lively was harassed. Oh, good lord. Ms. Lively having been the one harassed. Okay. I'll have to look at that later because I didn't, that attachment, paragraph 9, docket 1, I don't have that. I filtered it out because there was too many pages in this 1,030 page filing. So I'll have to look at that later. Plaintiff's lone paragraph attempting to show that Ms. Lively acted with actual malice, which relates to plaintiff's demonstrably false claim that Ms. Lively accused Wallace of sexually harassing her or of breaching a contract between the two, neither of which she alleged in the CRD complaint, does not satisfy actual malice's subjective test. As demonstrated by the filing of the amended complaint in the New York litigation, Ms. Lively believed when she filed the CRD complaint and believes now that plaintiffs engaged in a retaliatory social media campaign to harm her for speaking out about the sexual harassment and hostile workplace she endured. Such actions do not establish actual malice, but instead just the opposite. A genuine belief in harm caused to her by plaintiffs because the complaint fails to overcome the sexual harassment privilege, and Ms. Lively is entitled to her attorney's fees, costs, and damages for which she will separately file a motion to recover. Of course you will. All right. Here's the thing about the retaliatory social media campaign. I and many other people was fully prepared to like hear her out. I actually didn't know much about Justin Baldoni at all. I watched, Jane the Virgin or whatever. That's all I've ever seen him in. I've seen a lot of Blake and Ryan stuff, and I always had no reason not to like them, right? As if you can really know these people, but you know what I mean, like public perception and all that. So I remember the first thing I read involving any of this was her first lawsuit. And I remember thinking like, Jesus Christ, this is bad. If this really happened, this is bad. No sort of like real criticism. And I specifically recall saying, I've seen lots of stuff about her in social media and all that, but I don't like to judge people based on stuff that happened like a gazillion years ago. Because like, how much have I changed since that time? So like, why would I, But then, after I read his, the picture became a little bit clearer. And it turns out she is actually just a heinous bitch. I mean, nobody had to put that idea into my head, really. Because I went into it open to what she had to say. And then reading her, everything that kind of picked apart her claims and seeing where she was dishonest, that wasn't part of a retaliatory social media campaign. That was just the truth of what happened. And I can say that for a lot of people, at least most of the people I ever talked to about this. So, it's just frustrating. I used to think Justin Baldoni was really cringy. I think I said that in like earlier days making videos about this. It was just like, the feminism stick. It's like, it's cringy to me. But then like, I like to know what I'm talking about, which is why I read all these things. And I'm going to read the rest of all of this 1,000 something pages, just not on the camera. Because I need to know what I'm talking about and feel confident in what I'm saying and my opinions. Otherwise, I don't want to talk about it. It's why you guys don't see me talk about a lot of the stuff that comes out in the press regarding like people's personal lives and all that shit, because I don't really know, So, yeah, I looked into his like podcasts and all that, and I looked into his kind of background. I listened to his TED Talk and all that stuff. And, you know, people can say, well, that's just like, you know, people put their best foot forward in the public eye or whatever. But then I actually listened to what people had to say who have worked with him previously, and actually talked to a couple people that know him. And yeah, there's just no scenario where I feel like she comes out on the right side of this from a human standpoint. From where the law stands and like this whole 47.1 shit, I don't know how that's going to work out. But from a perception standpoint of like who was wronged here, it's not Blake Lively. So, you know, and I came to that conclusion on my own because of what she did here. Not because her hair care line sucked, which I've admittedly never tried and never will, because I use 2-in-1 shampoo from CVS. It's called Wookiee Waves. It has Chewbacca on it. Yeah, it's not because of stuff she said 15 years ago. It's because of what she did to a genuinely good person. And what she continues to do to a genuinely good person, and how she is absolutely ruining kind of the reputation of these laws that are in place to protect sexual abuse and harassment victims. So that's my problem. Right. Anyways, not satisfied with engaging in a retaliatory campaign on social media and elsewhere against Miss Lively for speaking out about the sexual harassment and hostile work environment she and others endured while filming It Ends With Us, plaintiffs now seek to drag her into a foreign court. Shut up. Almost 2,000 miles from home to further punish and harass her for privileged communications. Plaintiffs claim lacks merit and is futile on its face, and Miss Lively respectfully requests that this court dismiss this case with prejudice and award her attorney's fees and costs. And I respectfully request that you stop talking out of your ass on talk shows and in speeches. But hey, here we are, you know? All right. So these emails are relating to the acceptance of service and whether or not Brian Friedman actually said he would accept service of the lawsuit for Jed Wallace. I'm not going to read through these right now. We did see these before, so I don't think we need to do that. Oh, this was the notice of non-suit without prejudice. Okay, the 202 thing. Yeah, we don't need to do that. And this is Jed Wallace's declaration. I think it's from his motion to dismiss in the New York court, which we've already gone over. But let me see, because there was just a couple points in here that might be helpful. I have read Miss Lively's amended complaint and am familiar with the allegations against me and Street. Prior to the filing of the amended complaint, Miss Lively filed a complaint with the California Civil Rights Department. I understand the CRD complaint was provided to the press. The CRD complaint is attached as Exhibit 5, and the complaint attached to the CRD complaint is attached as Exhibit 6. Okay. My earliest involvement in my limited role concerning Justin Baldoni and Wayfarer was August 2024. I am the only employee of Street that engaged in that limited role. All of that limited work was done by me from Texas. None of that work was in New York. None of that work was directed at New York. Okay, one sec. Okay. Neither I nor Street posted anything on social media on behalf of the Wayfarer parties or about Lively, Reynolds, It Ends With Us, or any of Lively's or Reynolds' businesses. Neither I nor Street have ever asked or directed anyone to post about, comment on, or like any social media posts about It Ends With Us, Wayfarer, Justin Baldoni, Blake Lively, Ryan Reynolds, or any of their businesses or family. I never published, directly or indirectly, any information or content, negative or positive or otherwise, regarding Lively. I never met or interacted with her. He's also never met Justin Baldoni, to my knowledge. So I do not have a digital army in Los Angeles, in New York, or anywhere else. I do not have, work with, or direct a team in Hawaii. I have never been to Hawaii. I have an understanding of what a social combat or social manipulation plan could be, but that is not a service I provided related to the film, Wayfarer, Justin, Blake, Ryan, or any of the businesses or family. I do not specialize in executing confidential and untraceable campaigns across various social media platforms to shape public perception. In early August, I was contacted by Melissa Nathan about Justin and potential stories or social media attacks on him. My job was to read, analyze, and assess all forms of media and trends taking place with respect to various issues. This job was in line with my work generally with respect to all forms of media. Specifically, for the events related to Mr. Baldoni, my limited job was to conduct analysis of the media climates. In doing so, I reviewed all forms of media, analyzed the sentiment of the coverage, and then provided updates on my observations. Most times, my feedback took the form of informal comments that I made to Ms. Nathan, who I understood to be in California. After passively observing the social media environment, I saw an organic outpouring of support for Justin Baldoni in the film. This observation led to my comment, "We are crushing it on Reddit." My feeling, based on what I saw, was that no actions needed to be taken at that time, and that everyone should let the sentiment on the social media unfold organically. In addition to observing that people on social media organically supported Mr. Baldoni, there appeared to be a dislike for Miss Lively based on her tone-deaf promotion of the film. Therefore, my advice was not to do anything at that time and let the sentiment on social media continue to unfold organically. My limited work related to Justin Baldoni concluded in early November 2024. Neither I nor Street had anything to do with the production of It Ends With Us, and I was never on the set of the film. Because I provided feedback to Ms. Nathan, who I understood to be in California most, if not all the time, I only considered the impact of my work to be in California, so that's what they were citing when we just read. Okay. Neither I nor Street communicated or caused content to be provided to any journalists, content creators, or media entities anywhere, let alone New York. To be clear, I did not speak to any journalists at the New York Post or at the New York Times regarding the issues set forth in this lawsuit. My role on social media was merely passive observation and analysis of the social media environment as it pertained to It Ends With Us. Lively alleges, among other things, that I participated in a conspiracy to commit tortious conduct or unlawful acts against her. I did not. If that conspiracy even exists, which I doubt, I have no knowledge of it because I was not involved. I had and have no desire to torch Lively or her reputation, nor did I act on that imagined desire with anyone. On January 21st, Lively filed a Rule 202 petition against me in Texas. On February 4th, Lively non-suited the petition. A true and correct copy is attached as Exhibit 1, so we scrolled past that, but that's okay. On February 4th, I filed a lawsuit against Lively in the Western District of Texas, asserting claims for declaratory judgment and defamation. Lively's responsive pleading is due April 4th. That's past since, obviously, but a true and correct copy is attached. Yeah, okay. And then this here, so this redacted information here was related to his medical condition. And then, of course, you guys remember when she first filed a motion to dismiss, which was, politely only 800 pages and not 1,000. When she first did that, she decided, fuck it. And they outed his medical condition in her response. So that was kind of a fuck up. Travel to and from New York would be difficult financially for me. Please shut the fuck up. Sorry about that. Not only would consistent travel to and from New York be a major expense for me, it would disrupt my ability to make a living, as I do most of my work in Texas. I believe my financial resources pale in comparison to Lively and her husband. I declare under penalty of perjury that the foregoing is true and correct. All right. I don't think I really missed anything here. Yeah, we're good. All right. So that was it for the pages I'm going to go over tonight, but I'm going to go through the rest of the legislative history and all that, but I'm just not going to do it until tomorrow. And I'll probably just do that on my own. I'm not going to sit here and read a boring ass thing to you guys. Where is this admission she was on about in her comments? I don't know. I'm going to look for that. And then, like I said, I always do a shorter recap thing the next day. So I'll make sure to look at that and mention that there. But yeah, that's kind of weird. Kind of weird. Maybe they're just being picky with wording. I'm not sure. But I'm pretty certain that they did not admit to that. So, okay. Pandora Fox, thank you for the 2. Lauren, you're a warrior queen. This is insane. Well, thank you very much. I appreciate it. Gizmo the Magnificent. That's whoa, look at that cat. Look at that cat. Is that your cat? Or is that just like a cat you ripped off of Google? Okay. Thank you for the 10. For your Pacer fund, thank you. I appreciate that. Appreciate that. Okay. Tracy L. Markley, fitness and author, thank you for the 5. Appreciate it. Let's see. Gwen Campbell, thank you for the 10. Bless you for doing all the dirty work for us going through it all. Couldn't end the week without you in here after every day. Yo, I mean, God forbid I have a night off. I know what you mean, though. I know what you mean. Thank you. I appreciate that. Hillary, I think I said that right. Hillary? Ashley, thank you for the 14. I love your show. Gummy money for Canada. Thanks. Cheers, sister. You literally make my day. #addicted. Well, thank you very much. I appreciate you. Yeah, I'm probably going to have one tonight. We'll see. Just Ricardo, thank you for the 2. Lovelies. Hi, Lauren. You're the bestest. Thank you, man. Thank you. Appreciate it. All right. Well, it's good to see you guys chats in here and to get to go through that with you guys to end the week. Please, God, do not let anything else come out tonight because I want to go visit my mom and then go to bed. I don't know. Maybe I'll draw some swear words in my coloring book. Maybe. We'll see. But of course, if something comes up, I'll be back. So otherwise, I'll see you all tomorrow. Appreciate it. Thanks.